Hey everybody, I'm Joseph Piper of Granite Trademark Services, and I'm here today to talk about trademark distinctiveness. Every trademark that is registered with the USPTO has been determined to be distinctive, but not all trademarks are as distinctive as others. Now, what do I mean by this? Some trademarks are given broader protection legally to fight against alleged infringers, depending on how distinctive their trademark is. And I think it'll be easiest to show what I mean if we just kind of jump into the levels of distinctiveness. And the lowest level, a level that's not distinctive at all, is generic. So you cannot use generic words to describe products that you sell if you want trademark protection. So for an example, you can't start an Apple company and call it Apple Company and try to get a trademark on Apple Company, because you are selling apples as a company, and it would just create chaos if people could just trademark and prevent other people from using the word Apple in connection with Apple companies. So that's what a generic trademark would be, and those are not registrable, and you're not allowed to get trademark protection generally on those. The next level is a little bit more, it's a little bit something more than generic, but it isn't much, and they're descriptive trademarks. A descriptive trademark might be something like Dunkin' Donuts. Like, okay, you sell donuts and coffee, people can dunk the donuts. It's not particularly creative, but it's creative enough where people would say that it is maybe somewhat descriptive, but it's also not so descriptive to make it generic. Some trademarks are especially descriptive or are treated as descriptive include last names. So, for instance, if you had a company and it was called Piper Roofing, it would be treated by the trademark examining attorney as descriptive, and you would need to show that it has a secondary meaning. And to show secondary meaning that you have acquired distinctiveness in the name, you just need to show that there are consumers out there who are familiar with your brand. You've been at it for a while. Usually 5 years is a good amount of time. And then you can say, I've acquired distinctiveness. I know my trademark is a bit descriptive, but look at all this evidence, and then you are good to go because you have shown that your trademark is distinctive. And remember, no trademark can be registered at the USPTO if it is not shown to be distinctive. So the first two, generic and descriptive, might not be. Generic never can get trademark protection, but a descriptive trademark may or may not if they can show they have acquired secondary meaning. The third level of distinctiveness for a trademark is suggestive. And a good example of a suggestive trademark is Greyhound buses. Now, what I mean by suggestive is that if you think of the word or the name, such as Greyhound, you don't necessarily think buses. But if you think of a bus company, Greyhound buses is suggestive that the company is fast and reliable like Greyhound dogs. So that's a suggestive trademark, and the beauty with suggestive trademarks is they are inherently distinctive. So the examining attorney will not bother you with an office action if you have a suggestive trademark. The fourth level of distinctiveness is arbitrary. And an arbitrary trademark is just where you take one word that's completely unrelated to what you do and use it for what you do. A good example of that would be Apple. Apples have nothing to do with computers. Macintosh apples have nothing to do with computers, but you got Macs and Apple, and it's selling computers. That would be considered an arbitrary trademark, and its distinctiveness level is higher than suggestive, which means you create a wider range of protection for Apple to go after any alleged infringers for using the name Apple in the computer or online space. The last level of distinctiveness is fanciful, and that's when you make up a word for your product or goods. Example of that is Xerox. Xerox made up the word Xerox, started selling copiers, and they had a fanciful trademark that was very distinctive. However, Xerox did run into a problem when Xerox became almost generic as a replacement for the word copier. So you would say, hey, did you go Xerox that for me, rather than would you go copy that for me? And it almost became distinctive. That is what happened to trademarks such as Frisbee, aspirin, and escalator. Now, what Xerox did to make sure that they didn't lose their trademark rights like those other companies by genericide is that they spent millions of dollars in an ad campaign to show people how to use the term Xerox correctly. So, for instance, can you go to the Xerox copier to make me a copy? Or, I need a copy on the Xerox machine, or something like that. So that's distinctiveness levels. If you have any questions, feel free to leave comments down below, and I'll respond. Thanks, bye.